Hello, my dear students. Today, in Labor Law first paper, under Industrial Disputes Act 1947, we'll talk about the procedure of strikes and lockouts and prohibition on strikes and lockouts. This is video lecture 32, 32nd, and we are discussing Industrial Disputes Act 1947 about strikes and lockouts under unit number 4. So, my dear students, the procedure of strikes and lockouts in public utility services under section 22nd, 22, prohibition of strikes and lockouts. In the case of an employee, no employee can go on a strike in public utility service when there is a breach of contract. So, if some employee is breaching a contract and going for the strike, it is prohibited. And if the employees want to go on a strike, then before 6 months notice provided to the employer to show the intention of the strike. In public utility services we are talking. And after giving notice of 6 months, then within 14 months, no employee can go on a strike. After the expiry of 6 months, then employee are going on a strike. If conciliation proceedings is any conciliation proceeding is pending, then strike is not possible. And after 7 days of concluding the proceedings, no one can go, no worker can go for the strike, and no strike has happened. In case of an employer, no employer can declare a lockout in public utility service. If employers want to go on lockout, then before 6 month notice is given to employees. After giving notice 14 days, no employer can go on lockout. After the expiry period of 6 months, employers can do a lockout, and if conciliation proceeding is pending and no employer can go on strike, I beg your pardon, in lockout. And after 7 days of the conclusion of the proceedings, employers do a lockout. If there is a strike or lockout already in existence, then there is no need to send a notice, but the employer sends intimation to the authority specified by the appropriate government, and notice given to the authority of that particular reason or otherwise given in general. So, my dear students, if the strike or lockout already in existence, then there is no need to send a notice, but the employer sends intimation to the authority specified by the appropriate government, and notice given to the authority of that particular reason or otherwise given in general. The notice of a strike given to any employer in a prescribed format and mention the number of employees who participated in the strike, and the notice of lockout, I beg your pardon, and the notice of lockout given to any employee in a prescribed format. So, my dear students, the notice of a strike given to any employer in a prescribed format, the format is prescribed under the law, under the act, and mention in this format the number of the employees will also be mentioned that who will be participating in the strike, and the notice of lockout given to any employee in a prescribed format. Now, my dear students, we talk about the general provisions of strikes, and the provisions of section 23 are general in nature and imposes general restrictions on declaring a strike in breach of contract in the both public as well as non-public utility services in the following circumstances mainly. A, during the pendencing of conciliation proceedings before a board until the expiry of 7 days, after the conclusion of such proceedings. D clause, during the pendency and 2 months after the conclusion of proceedings before a labor court, tribunal, or a national tribunal. C, during the pendency and 2 months after the conclusion of arbitrator, when a notification has been issued under subsection 3, clause A of section 10A, and clause D, during any period in which a settlement or reward is in operation in respect of any of the matter covered by the settlement or award. And section 23 says that no employer declared lockout in any establishment, and workers of establishment also not declare strike when these conditions has happened. As I told you, if the conciliation proceeding is pending before a board, and after 7 days of concluded of the conciliation proceedings, if a proceeding is pending in labor court, national tribunal, then no employer and employee can go on lockout and strike after 2 months of concluded proceedings. So, and if a proceeding is pending before arbitration and 2 months after the conclusion, when the notification is given under subsection 3A of section 10A, then also no strike and lockout can be declared, as we have already gone through this. And if the settlement or reward is pending, then also no one can declare a strike and lockout. Now, my dear students, we will throw some light on that when a strike is declared as illegal strike. So according to section 24, when a strike and lockout is in contravention to the provisions of the section 22 and or 23, then strike and lockout declared illegal. I repeat, my dear students, that when a strike and lockout is in contravention to the provisions of section 22 or 23, then strike and lockout declared illegal. And it was also declared illegal when it contravenes the provisions of subsection 3 of section 10. So then these kind of strikes becomes illegal strikes. And if a strike or lockout is running between, this dispute is referred to arbitration, labor court, tribunal, or the national tribunal, but the strike and lockout are not illegal if they are not contravening the provisions of the strike and lockout. And if an illegal strike or lockout is already there, then to which this declare as a strike and lockout. Section 25, prohibition of financial aid to illegal strikes and lockouts. Section 25, prohibition of financial aid to illegal strikes and lockout. So section 25 of Industrial Disputes Act says that there would be a provision of financial aid to illegal strikes and on illegal lockouts. No person can apply for the money directly to illegal strike and lockout if he knows well. If the person is aware, the workman is aware that they are going for illegal strike, or the employer is aware that they are going for illegal lockout, then if they know this fact, then they will not go. There would be a provision on the financial aid to the legal strikes and the lockouts. And further, strike and lockout is declared when the situation is out of control. So, as a routine, in routine course, we do not go for the strikes and lockouts. When the situation is out of control, then we go for these things. And a strike or lockout does not provide benefits to anyone. Yes, true. Because for healthy industrial relations in the industry, we have to have, the good industrial relations. If we want to have, then we should discourage these practices of strikes and lockouts, because strikes and lockouts will not lead to the harmonious relationship between the employer and employee. And it is a very serious decision also, whether the employees are deciding to go for the strike or the employers are deciding to go for the strikes. It would be a very serious decision. And before declaring a strike or lockout, negotiation is done between management and workers. But when the things are not so good after that strike or lockout, then the strike and lockout would be declared. So before declaring the strike or lockout, negotiation will be done between the management and the workers. But when these things are not working well, then strikes and lockouts would be declared. So the employer side and employees, both the parties will try to resolve the issue and will just try to avoid, on the part of the employees, they will try to avoid the strike, and on the part of the employer, they will try to avoid the lockouts, employers. And this system has come to stop the exploitation of the workers, because workers have no power to stand in front of the management. Because the purpose of the strike was that the employees would be united, and if they are demanding something, they are united, and then they are demanding something to their employer, then employer will hear their voice and will give a witness to their voice. So this was the ultimate purpose of these strike provisions. Or the same is applicable to the lockout also, that employer wants that employee should understand the problem of the employer also. And strike and lockout is a kind of weapon, as a strike is a weapon available to the trade unions or the workers or the workforce to just put their demands. Likewise, the lockout is a weapon available to the management. And if the industry makes a healthy relationship between employees and employers, then this situation has never come. Neither the employers will go for the lockout nor the employees will go for the strike. They will amicably resolve the differences and will resolve the issues as well. And the effort to improve the relationship is on both sides, employees as well as employers, so that they live with peace and harmony. Because see, for industrial peace and harmony, the employers and the employees, they should understand each other, and they should go in a very empathetic way. They should understand the problems of each other, and then they should try to resolve the grievances or the issues of each other. Section 24 of the Industrial Dispute Act 1947 lays down the grounds which make the strike and lockout illegal, which are if the strike and lockout commenced or declared in contravention, as I have told you, the section 22 under the ID Act in Public Utility Services, and under the provision section 22, a worker as well as the employer is required to serve a valid notice within the period prescribed by this section before a strike or a lockout, as the case may be, and can be illegal or justified under the said Act, as that we have covered in the previous slide also. And a strike or lockout shall be illegal if it is commenced in contravention of section 23 of the ID Act, Industrial Dispute Act, in any industrial establishment, under the provisions of the section 23, strikes and lockouts are prohibited. In case the matter under dispute pending before the arbitrator, board of conciliation, labor court, industrial tribunal, national tribunal, any or during any period in which settlement or award is in operation in respect of any of the matter covered by the settlement or the award. And my dear students, here I would like to draw your kind attention to the countrywide strike done by the, a number of trade unions were united. And in 2015 also, 16 also, this countrywide union strike was there. So I suggest you all, I recommend you that please go through that countrywide strike, 2nd September strike. If you search on Google, then you will find it, and you kindly go through that case, that what were the demands. And likewise, you can refer the case of Maruti Suzuki also. In Maruti Suzuki Manesar plant, the trade unions, they were agitating and they were just demanding for the rights of the workers. And there are certain other examples also. If you talk about the case of Greater Noida Graziano, or you talk about the case of Sahibabad Allied Nippon, where the manager was assassinated, and the same thing happened prior to this in Greater Noida Graziano also. So these are the examples that because of these trade unions and because of the industrial disputes, the industries means they do not go in a well manner to achieve the targets. So we should discourage these practices of strikes and lockouts. Now we talk about strike and lockout, that a strike or lockout shall be illegal if it is continued in contravention of an order and by the appropriate government under section 10 subsection 3 or under subsection 4 clause A of section 10A of the said act. Thank you so much, my dear students. I believe this lecture will give you an input about the strike and lockout, and you will understand well that how these strikes and lockouts are prohibited, and only under certain circumstances by serving the proper notices the employees or the workforce, they can go for the strikes, or the if the case is of an employer, then means they need to intimate the employees and then only they can go for the lockout. So once again, my dear students, I suggest you that please go through the countrywide 2nd September strike 2015-16 in the year 2015, 16, 17, 18. You can just check with the help of Professor Google, and you can refer the cases of Maruti Manesar plant case, where the trade union uh, office bearers, the trade unions, the workers, the workforce, they were just demanding for their rights, and there was a tussle between the employer and employees. And then you may refer to the Graziano case, Greater Noida. You may refer to the Allied Nippon case also. So once you go through these cases, I believe these cases will give you an insight about this strike. Then how do these trade unions or the workers, they go for the strike. So this is all for today's lecture, my dear students. I believe this lecture will help you. Thank you so much. Go through the PPTs, go through your notes, and try to understand these concepts. Thank you so much. Have a nice day. Have a nice time. Take care. Bye-bye.